Love knows no boundaries, but the law hasn't always agreed. For same-sex couples, the journey to legal recognition has been a story of struggle, triumph, and transformation. One that affects not just the heart, but every aspect of financial and family planning. In this powerful second video of our estate planning for same-sex couples series, we'll explore how hard-won legal victories have paved the way for equality in estate planning, and why understanding your rights is the key to securing your legacy and protecting the ones you love most. Historical context of same-sex relationships. Throughout history, the perception and treatment of same-sex relationships have varied significantly across different cultures and time periods. Understanding the historical context of same-sex relationships is crucial in recognizing the struggles and progress that have shaped the current legal and social landscape for LGBTQ+ individuals. Ancient civilizations. Same-sex relationships have been documented in various ancient civilizations, such as ancient Greece and Rome, where they were often accepted and even celebrated. In ancient Greece, relationships between older men and younger boys were common and considered a normal part of society. Similarly, in ancient Rome, same-sex relationships were not uncommon, though the social acceptance varied depending on the individuals involved. Religious influence. The rise of organized religions, particularly Christianity, brought about significant changes in how same-sex relationships were viewed. Many religious doctrines condemned homosexuality as sinful, leading to widespread discrimination and persecution of LGBTQ+ individuals throughout history. The criminalization of same-sex relationships in many societies can be traced back to religious beliefs that deemed such relationships as immoral or unnatural. Legal persecution. In more recent history, laws criminalizing same-sex relationships have been prevalent in many parts of the world. For example, in the United States, laws prohibiting sodomy and same-sex marriage were enforced for decades, denying LGBTQ+ individuals basic rights and protections. The legal persecution of same-sex couples has had long-lasting effects on their ability to access legal benefits, such as inheritance rights and healthcare decisions. Social movements. The 20th and 21st centuries have seen significant social movements advocating for LGBTQ+ rights and equality. The Stonewall riots in 1969 marked a turning point in the fight for LGBTQ+ rights in the United States, leading to increased visibility and activism for the community. Over the years, same-sex relationships have become more widely accepted, leading to advancements in legal recognition and protections for LGBTQ+ couples. Legal progress. In more recent years, there have been significant legal advancements in recognizing and protecting the rights of same-sex couples. The legalization of same-sex marriage in many countries, including the United States, has been a landmark achievement in the fight for equality. Additionally, anti-discrimination laws and legal recognition of LGBTQ+ relationships have helped to ensure that same-sex couples have access to the same rights and benefits as heterosexual couples. Understanding the historical context of same-sex relationships provides valuable insight into the challenges faced by LGBTQ+ individuals and the progress that has been made in advancing equality and recognition for same-sex couples. As laws and societal attitudes continue to evolve, it is essential for same-sex couples to stay informed about their rights and options when it comes to estate planning and ensuring their wishes are protected. Legal developments and recognition of same-sex marriage. In recent years, there have been significant legal developments and advancements in the recognition of same-sex marriage. Prior to the landmark Supreme Court decision in Obergefell v. Hodges in 2015, same-sex couples faced numerous legal challenges and barriers when it came to marriage and estate planning. However, the ruling in Obergefell v. Hodges legalized same-sex marriage nationwide in the United States and marked a major turning point in the legal landscape for same-sex couples. Following the Obergefell decision, same-sex couples are now afforded the same rights and privileges as opposite-sex couples when it comes to marriage. This includes important estate planning considerations such as inheritance rights, tax benefits, and spousal benefits for retirement accounts and Social Security. One key aspect of estate planning for same-sex couples post-Obergefell is the ability to take advantage of marital deductions and exemptions for estate and gift taxes. Prior to the legalization of same-sex marriage, couples were not able to benefit from these tax advantages, which often resulted in higher tax liabilities for surviving partners. Now, same-sex spouses can transfer assets to each other during life or at death without incurring gift or estate taxes, similar to opposite-sex married couples. Another important consideration for same-sex couples is the ability to access Social Security benefits based on their spouse's work record. Surviving spouses are now eligible for Social Security survivor benefits, providing financial security and support in the event of the death of a spouse. Furthermore, the recognition of same-sex marriage has implications for healthcare decision-making and end-of-life planning. Married same-sex couples now have the legal right to make medical decisions for each other and to inherit property from a deceased spouse without the need for special legal arrangements or documents. The legal developments and recognition of same-sex marriage have greatly improved the estate planning options and protections available to same-sex couples. It is important for couples to consult with estate planning professionals to ensure that their plans are up to date and reflect the current legal landscape surrounding same-sex marriage. Implications of legal recognition on estate planning. Legal recognition of same-sex relationships has profound implications on estate planning for couples. Prior to legal recognition, same-sex couples faced significant challenges in ensuring their assets and wishes were protected in the event of incapacity or death. With legal recognition, same-sex couples now have access to a range of estate planning tools and protections previously unavailable to them. 1. Spousal rights and protections. Legal recognition of same-sex relationships grants couples spousal rights and protections similar to those enjoyed by heterosexual married couples. This includes the right to inherit from a deceased spouse's estate in the absence of a will, the ability to make medical decisions on behalf of an incapacitated spouse, and access to certain tax benefits and exemptions. 2. Intestate succession. In the absence of a will, intestate succession laws dictate how a deceased person's assets are distributed. Legal recognition ensures that same-sex spouses are included in these laws, allowing them to inherit from each other's estates if no will is in place. 3. Joint ownership and beneficiary designations. Legal recognition enables same-sex couples to hold assets jointly and designate each other as beneficiaries on various financial accounts and insurance policies. This simplifies the transfer of assets upon death and ensures that the surviving spouse is provided for according to the couple's wishes. 4. Estate tax planning. Same-sex couples can now take advantage of estate tax planning strategies previously reserved for married heterosexual couples. This includes utilizing the unlimited marital deduction to transfer assets to a surviving spouse without incurring estate taxes, as well as implementing trusts and gifting strategies to minimize tax liabilities. 5. Healthcare directives and powers of attorney. Legal recognition allows same-sex couples to establish healthcare directives and powers of attorney that grant their partners the authority to make medical and financial decisions in the event of incapacity. This ensures that the couple's wishes are respected and that the surviving spouse has the legal authority to act on behalf of their partner. The legal recognition of same-sex relationships has a transformative impact on estate planning for couples, providing them with essential rights, protections, and planning opportunities previously denied to them. It is crucial for same-sex couples to consult with an experienced estate planning attorney to navigate the complexities of estate planning and ensure their wishes are carried out in accordance with the law. Differences in state laws and their impact on estate planning for same-sex couples. Estate planning for same-sex couples can be complex due to the variations in state laws across the United States. Understanding the differences in state laws and their implications is crucial for same-sex couples to effectively plan their estates and protect their assets. 1. Recognition of same-sex relationships. Some states fully recognize same-sex marriages and domestic partnerships, providing legal protections and rights similar to those for opposite-sex couples. However, other states do not recognize same-sex relationships, which can lead to challenges in estate planning for same-sex couples residing in those states. 2. Intestacy laws. In states that do not recognize same-sex relationships, intestacy laws may not automatically grant inheritance rights to a surviving same-sex partner. Same-sex couples may need to create wills or other estate planning documents to ensure that their assets are distributed according to their wishes. 3. Taxation. Tax laws related to estate planning can vary significantly between states, impacting same-sex couples differently based on their location. Some states may impose estate or inheritance taxes on same-sex couples that are not applicable to opposite-sex couples, affecting the overall estate planning strategy. 4. Healthcare directives. State laws also govern healthcare directives, such as living wills and medical powers of attorney, which allow individuals to make important healthcare decisions for their partners in case of incapacity. Same-sex couples may encounter obstacles in states where their relationships are not legally recognized, potentially limiting their ability to make healthcare decisions for each other. 5. Property ownership. State laws regarding property ownership, such as tenancy by the entirety or community property, can impact how assets are distributed upon the death of one partner. Same-sex couples may need to navigate state-specific property laws to ensure that their assets are passed on to their partners without complications. Navigating the differences in state laws is essential for same-sex couples to protect their interests and ensure that their estate planning goals are met. Consulting with legal professionals who are well-versed in estate planning for same-sex couples can help individuals understand the nuances of state laws and develop comprehensive estate plans tailored to their specific needs and circumstances. The legal recognition of same-sex relationships isn't just about paperwork. It's about love, equality, and the right to protect what matters most. Your relationship deserves the same respect and security as anyone else's, and your estate plan is a testament to that love. By understanding the laws, preparing thoughtfully, and working with professionals who champion your rights, you ensure that your legacy is honored and your partner is safeguarded, no matter what the future holds. Let your estate plan be a bold declaration. Your love is here to stay, and your story deserves to be protected for generations to come.